Hello everyone. In this video we will do some important MCQs of POCSO Act, which is Protection of Child from Sexual Offences Act 2012, and the same act is part of Delhi Judiciary as well as MP Civil Judge examination. So I have made questions which are little analytical and are not directly based on index questions asking deadlines or time periods, statutory periods. So in this video we will get some analytical questions. So let's begin. Question number 1 is that objective of enacting the POCSO Act 2012 is, first option is to protect the children from various types of sexual offences. Second says establish special court for providing speedy disposal of cases. Third option is sexual offence against a male child is also covered under POCSO Act. So these three options, it seems like these all are correct, because the act provides especially to protect the child from sexual offences, as well as it provides for a special court, and also it is a gender neutral act. So all three options are correct. So correct option would be, answer would be all of these. Next question is, when the age of the victim is to be assessed or ascertained, how the same is to be determined? First option is section 94 of the Juvenile Justice Act is attracted in such a case. Second option is POCSO Act itself provides for the determination of age in case of doubt as to the age of victim. Third says age is to be determined by a specialist. So fourth is none of these. The correct answer would be, as there is no such provision in POCSO Act to determine the age of the victim, the child. So in such a case, the special court in case of uncertainty, in case of dispute about the age of the child, the court takes course of section 94 of the Juvenile Justice Act, as it provides for the procedure that how to determine the age of the juvenile in the act. So the same provision is applicable when there is a dispute, doubt as to what is the age of the child in question there, who is victim there in the POCSO Act as well. So correct answer is section 94 of the Juvenile Justice Act. Third question is, which amongst these is correct regarding penetrative sexual assault? First option is, whoever commits penetrative sexual assault shall be punished with imprisonment of either description for a term which shall not be less than 20 years, but which may extend to imprisonment for life, and shall also be liable to fine. Second, penetrative sexual assault defines under section 4 of the Act. Defined under section 4 of the Act. Third option is penetrative sexual assault excludes sexual assault to a boy. Fourth, penetrative sexual assault includes sexual assault by a woman. So see these options. The punishment provided for penetrative sexual assault in the first option, it has provided punishment for aggravated penetrative sexual assault, so it is not the answer. Second says that sexual assault it is not defined in section 4, it is punishable under section 4. Third says it excludes sexual assault to a boy, so boy is included in the definition. Fourth provides penetrative sexual assault includes sexual assault by a woman, which is a correct option. So a woman can also be liable to for committing sexual assault under the POCSO Act. So as the act is gender neutral, a woman can also be liable for the punishment under POCSO Act. So fourth option is correct and right answer. Question number 4, aggravated penetrative sexual assault includes, first, whoever commits penetrative sexual assault on a child and attempts to murder the child. Second, whoever commits penetrative sexual assault on child and causes death of the child. So here is the attempt, and here it is causing death of the child. Third is penetrative sexual assault by a public servant, and all of these. So if you see the definition properly, aggravated penetrative assault includes all of these options. So correct answer is fourth. Fifth question is, which amongst these is incorrect with regard to sexual assault under POCSO Act? So first option is, any act with sexual intent which involves physical contact without penetration is sexual assault. Without penetration and involves physical contact with sexual intent. Second, punishment for sexual assault is imprisonment for not less than 3 years, but which may extend to 5 years. Third says nature of the imprisonment in case of aggravated sexual assault is rigorous imprisonment, and imprisonment of either description in case of sexual assault. And 4 says all of these are correct. So kindly see the options. In the options, this punishment is correctly written. It is 3 years, but which may extend to 5 years. First option is also correct. It provides sexual intent which involves physical contact without penetration is sexual assault. So this is also correct option. In option number 3, the nature of the imprisonment in case of aggravated sexual assault is rigorous imprisonment, and imprisonment of either description in case of sexual assault. But this option is incorrect, because in both of the cases it is incorrect that rigorous imprisonment is provided in aggravated sexual assault. So the incorrect option, it is asked in the question, so incorrect option is option number 3. It is not all of these, it is number 3 is the correct answer. Again, next question is which amongst these is correct. First option is question as to sexual intent is irrelevant for offences under POCSO Act. It means that sexual intent is irrelevant. It is immaterial whether there was sexual intent by the accused or not. The second option says offence punishable under POCSO and IPC, the accused cannot be tried for both. So if something done by the accused falls under POCSO as well as IPC, it is saying that accused cannot be tried for both. Third option is showing part of body to the child with sexual intent comes under the category of sexual assault. And fourth option is sexual gratification is an essential element in case of offence of using child for pornographic purposes. So which among these is correct? So correct option 4 is the correct answer, because sexual gratification is essential element in case of offence of using child for pornographic purposes. Option 1 is saying sexual intent is irrelevant. It is incorrect. Sexual intent is relevant. Second is saying POCSO and IPC, the accused cannot be tried for both. It can be tried for both. Showing part of body to the child with sexual intent comes under the category of sexual assault. It is incorrect. It is not sexual assault. It is not falling under the definition of sexual assault. So correct answer is 4th. Next question, punishment for attempt to commit an offence under POCSO Act is. So attempt to commit offence under POCSO Act. So what is the punishment as per the Act? So option 1 is punishment with imprisonment of any description provided for the offence for a term which may extend to 1/2 of the imprisonment for life. 1/2 of the imprisonment for life, which means 1/2 of 20 years, or as the case may be 1/2 of the longest term of imprisonment provided. Second option is provided with imprisonment of any description provided for the offence, punished with the imprisonment of any description provided for the offence for a term which may extend to 1/2 of the imprisonment for life, or as the case may be 1/4 of the longest term of the imprisonment provided. The third option is punished with imprisonment for any description provided for the offence for a term which may extend to 1/2 of the imprisonment for life, which means 1/2 of the 20 years, or as the case may be 1/4 of the longest term of the imprisonment provided. So the correct option is option number 1. It provides punishment with imprisonment of any description provided for the offence for a term which may extend to half of the LI, which means 20 years. So as you know, section 57 of IPC provides fraction of LI, which means 20 years. Fraction means that whenever you have to calculate half of the LI, so LI means in POCSO Act till the remainder of your life, which means the rest of your life remaining. For that period you are sentenced. So sentence for life means remainder of your life in the POCSO Act. But when we have to calculate half of the LI punishment sentence, it is to be taken as 20 years in fraction as per section 57 of IPC. So the correct answer would be option number 1, which provides LI for life, punishment for LI, which means 20 years, 1/2 of the 20 years, as the case may be 1/2 of the longest term of the imprisonment provided. So it is as per the Act provides half of the sentence in case of attempt to commit offence under POCSO. So option number 1 is correct. Next question is storage of pornographic material involving child is exempted liability of commission of offence if, first option, if stored without an intention to share or transmit child pornography. Second is if stored for purpose of reporting the offence to authority. And third is if stored as evidence to be used in courts of law. So as per the act, if intention is not to share or transmit the child pornography, it is stored without such intent, because you have to understand this, that it is, the punishment is for storage. So you are, that does not mean that you are making a pornographic material. It is not for that. It is exemption that if you are storing it without an intention to share or transmit child pornography, it is not punishment if you carefully read the definition. But if you are storing it with intention to share or transmit it, it is punishable. Second option, if you are storing it for the purpose of reporting the offence to the authority and as evidence, so in all of three cases it is not punishable, it is exempted from the liability of offence. So option 4 is the correct answer. Number 4, all of these are correct. Next question is, which amongst these is incorrect with respect to reporting of the offence under POCSO? So incorrect option we have to answer. First option is, possibility of commission of offence under the act is sufficient to report the offence to the police. Actual occurrence of the commission of offence is not necessary for the reporting. This option is correct because in POCSO, the actual commission of offence is not required to report it. Even if it is the apprehension, the possibility that this offence may be committed, which may make a liability under POCSO Act, that then a report can be made. The second option is, information as to commission of an offence under the Act can be given to the special juvenile police unit only, which is incorrect option. As per the POCSO Act, either juvenile police unit or the local police, information can be given to either of the those authorities. So second option is incorrect. Other 3 or 4 automatically would be correct, but we can read it. Third option is, the special juvenile police unit shall within a period of 24 hours report the matter to the child welfare committee and a special court, or where no special court has been designated, to court of session. Fourth, saying report of the offence can be recorded by any person. So yes, report can be recorded by any person regarding commission of offence, but the incorrect option is option number 2. Next question, which amongst these is incorrect statement? First, in case the victim is girl child, the medical examination shall be conducted by a registered women medical practitioner. Second, magistrate or police, either of them can assure the recording of the statement of child through audio video electronic means. So पुलिस और मैजिस्ट्रेट कोई भी ऑडियो वीडियो रिकॉर्डिंग कराना अश्योर करा सकता है. दिस इज द सेकंड ऑप्शन. थर्ड सेज, प्रेजेंस ऑफ द एडवोकेट ऑफ द अक्यूज इज बार्ड at the time of recording the statement of the child under POCSO Act. Fourth is all of these are correct, but the correct answer would be, as it is asked, which amongst these is incorrect. So if you see and read the provisions properly, the answer would be option number 1, because it is not required as per the Act that medical examination shall be conducted by a registered women medical practitioner. Only women doctor is there probably in the Act. It is not medical practitioner. So incorrect option is option number 1. Next question is, which amongst these is correct? So what is the correct option? Option number 1 is, POCSO Act provides reverse presumption which presumes the guilt of the accused. Therefore, a fact is to be proved on the basis of principle of preponderance of probability. It is saying that in POCSO Act, it provides reverse presumption. So therefore, the fact is to be proved on the basis of principle of preponderance of probability. Second option says, accused charged under IT Act, Child Protection Act, ST/SC Act and POCSO Act shall be tried under Atrocities Act, because caste of the child would be special right protected under that special act. So if he is charged under all of these acts, he will be tried under Atrocities Act, because caste is a special subject, thus he will be tried under that special act. Now third option says, a special court may take cognizance of any offence without the accused being committed to it for trial. It is provided in the POCSO Act that a special court may can take cognizance of the offence without accused being committed to it for the trial. Thus, the remand of the accused shall always be given by the special court only. And fourth option is none of these. So if you see the options properly, the correct option would be option number 4, none of these, because all the options are incorrect. See why? First option is saying there is reverse presumption under POCSO Act. Yes, it is correct, there is reverse presumption, but as per the Act, the fact is still to be proved on the basis of principle to be proved beyond the reasonable doubt. So one still has to establish facts beyond the reasonable doubt under the POCSO. It is there in the POCSO Act as well that fact is to be established beyond a reasonable doubt only. It is not, it is expressly written, it is not to be proved on the principle of preponderance of probability. Correct. So second says accused charged under IT Act and Child Protection Act, ST Act, POCSO, all of these tried, he will be tried in the ST Act, which is incorrect. He will be especially a subject as a child here in POCSO Act, so he would be tried under POCSO Act only, even if the offence attracts all of these acts. So it is also incorrect. Now third option is a special court may take cognizance of any offence without the accused being committed to it for a trial. Yes, it is correct until this portion. Thus, that remand of the accused shall always be given by the special court only. It is incorrect, because remand of the accused can, for the first time, when he is for the first time being forwarded to the magistrate, he can give remand for the very first time. Later on, after first remand, the remand will be given by only the special court under POCSO Act. So partially it is incorrect option. First remand can always be given under section 167 of the CRPC by the magistrate, and it is not required that even the first remand should be given by the special court. So none of these is the correct answer. Next question is, which amongst these is correct? First option, special court shall conclude the trial within 12 months from the date of filing of charge sheet. Second option is, special court shall ensure that the accused is not in a position to hear the statement of child. Third option is, trial under the POCSO Act to be conducted in camera and no one must be present with the child. And fourth option is none of these. So the correct answer would again be none of these. Why? First option says a special court shall conclude the trial within 12 months. Yes. From the date of filing of charge sheet? No. It is cognizance, from the date of taking cognizance. So again, first is wrong. Second says a special court shall ensure that the accused is not in a position to hear the statement of child. It is incorrect, because it is there that interaction should not be there with the child. Hearing the statement of child is his right of accused, so it is incorrect. Third is, trial under the POCSO Act to be conducted in camera and no one must be present with the child. It is also incorrect, because the parent or person in whom the child having confidence or trust, he must be there with the child at the time of recording of statements or evidence. So none of these is the correct answer. Next question is, in which of these cases Supreme Court held that the procedure to determine the age of a child in conflict with law can be used to determine the age of child victim under POCSO Act? So what is the case in which this was held? The options are Jarnail Singh versus State of Haryana, Nipun Saxena versus Union of India, Kanha versus State of Maharashtra, Rajiv Ghosh and others versus the State of Assam. The correct answer is option number 1, Jarnail Singh, which is very popular judgment. In this judgment, it was held that the procedure provided in Juvenile Justice Act to determine the age of the child victim under POCSO, to determine the age of juvenile in the Juvenile Justice Act, that procedure can be also adopted in this POCSO Act. So this was the Jarnail Singh versus State of Haryana, 2013. This is the judgment. Now next question is, the POCSO Act was enacted by the central government with the help of. So who ultimately drafted the act? Who helped in drafting this POCSO Act? Options are, first, Ministry of Home and Child Development, second, National Commission for Protection of Child Rights, third, National Commission for Women, fourth, National Human Rights Commission of India. So correct answer is first, Ministry of Women and Child Development. This ministry made the guidelines for the POCSO Act and which later converted into this act. Next question again, what is correct regarding punishment under POCSO Act? So what is the correct regarding punishment under POCSO Act? Options are offences proved under POCSO as well as IPC, the accused would be sentenced under the act providing punishment lesser in degree. Second says the life imprisonment under POCSO Act means imprisonment for 20 years as fraction for LI is 20 years. Third says the special court can award punishment both under POCSO Act as well as IPC if the facts of the case is falling under both the acts. So the correct option would be none of these. All these statements are wrong. First option says that when POCSO and IPC both are attracted, the accused would be sentenced under the act providing punishment lesser in degree. In the act it is greater in degree, providing greater punishment. The accused would be sentenced under that law, that act. Second says that life imprisonment under POCSO means remainder of life, not 20 years. Fraction is only for calculating the half of or 1/4 of the LI, so it is not applicable here. Third says the special court can award punishment both under POCSO as well as IPC if the facts of the case is falling under both the acts. It is also incorrect because as per section 42 of the POCSO Act, section 42, kindly see, the special court can award punishment either under POCSO or under IPC. It cannot provide sentence under both the acts. You can see even today the special courts are not giving attention to this provision. It is provided under the act that the offence can be proved under both IPC and POCSO Act, both at the same time, but the sentence can be awarded under either of the laws. Either you can award sentence under POCSO or IPC. You cannot award sentence to under both the acts. So even today there are so many courts, so many states in which special courts are still awarding sentence under IPC as well as POCSO under both the acts. So which is incorrect practice. As per section 42, you can prove, as a judge you can prove both the offence under both the acts, but can award sentence only either of them. So the correct answer is none of these. Next question is the police or special juvenile unit to report the matter of child sexual abuse to the child welfare committee within what time period? So the first option is 24 hours of report. Second says that's 24 hours of commission of the offence. Third says 18 hours of the crime, 48 hours of the report. The correct answer is 24 hours of the report. Next question is the enforcement date of the POCSO Act. So November 14, 2012, November 14, 2013, November 12, 2012, November 15, 2014. The correct option is first November 14, 2012. Next question is 283rd report of Law Commission of India regarding age of consent in POCSO Act recommends. So इसमें से क्या 283rd report of the Law Commission of India एज ऑफ कंसेंट के रिगार्डिंग जो रिपोर्ट की थी उसमें से इसमें से क्या रिकमेंड करती है? सो द फर्स्ट ऑप्शन इज दैट रिड्यूसिंग द एज ऑफ कंसेंट वुड गिव लीड टू राइज इन चाइल्ड मैरिजेस. अगर एज ऑफ कंसेंट को रिड्यूस किया जाएगा तो दिस विल रिजल्ट इन rise in the child marriages. Second option says any element of consent is going to be an easy escape route for the adult abusers, thereby enabling prostitution and exploitation of the children. So then third option is it recommends amendment to the Juvenile Justice Care and Protection Act 2015 so that cases under POCSO Act in which both the parties are aged between 16 to 18 years can be dealt with the Juvenile Justice Board instead of criminal courts. And fourth option says it recommends amendments that introduce guided judicial discretion in the sentencing of cases involving consent. So if you read this report, you find that all of these are correct. All of these views are taken under the these recommendations are given by the Law Commission of India. So all of these is the correct answer. Next question is the POCSO Act does not prevent magistrate from ordering first remand of an accused under the act, but the subsequent remand orders or bail application should be made only before the special court under the POCSO Act, as we discussed earlier. So this was the case Prasad versus State of Kerala. This is the citation. In this case, it was held that all. Next question is use of two finger test was held unconstitutional. So what is the case? And also Supreme Court held that the two finger test and its interpretation violates the right of rape survivors to privacy, physical and mental integrity and dignity. So in the same case it was held that, and two finger test was held unconstitutional. So out of these cases, third option, Lilu versus State of Haryana, AIR 2013, this is the case in which this was held, the two finger test was held unconstitutional. Lilu versus State of Haryana. Now next question is which of the following statements is correct pertaining to the provision of recording of statement of a child. So first option is statement of the child shall be recorded by a police officer not below the rank of sub-inspector. Second option says the statement of the child shall be recorded by a woman police officer not below the rank of inspector. Third says the statement of the child shall be recorded by any police officer below the rank of sub-inspector. And fourth option is the statement of the child shall be recorded by a women police officer not below the rank of sub-inspector. If you read the provision, you have read the provision, then you will find that fourth option is the correct. It must be a women police officer and should not be below the rank of sub-inspector. So fourth is the correct answer. Next question is the special court shall try the cases in camera in the presence of. So the first is the person who gave the information or complaint, in the presence of accused, in the presence of parents, and fourth says that no one should be present while trying the cases under POCSO Act. But you see the provision properly, there is written in the provision that parents must be present, or either the person, the child having a trust in or confidence in must be present with the child. So correct answer is third. Next question is what changes were made by the POCSO Amendment Act 2019. 2019 में जो अमेंडमेंट हुए हैं उसमें क्या चेंजेस पॉक्सो एक्ट के अंदर हुए हैं. सो दीज आर दी ऑप्शंस. फर्स्ट, मिनिमम पनिशमेंट फॉर पेनिट्रेटिव सेक्सुअल असॉल्ट इंक्रीज फ्रॉम 7 to 10 years. Second is it added in the act that if the person commits penetrative sexual assault on the child below the age of 16, he'll be imprisoned for 20 years to life with a fine. And third says that it added that death due to penetrative sexual assault as aggravated penetrative sexual assault. So if you read the provisions and you read this amendment act, all of these are correct. All of these were added, all of these changes were made in the act. So all of these are, the fourth option is correct. Next question is the Honorable Supreme Court in Ashwini Kumar Saxena versus State of Madhya Pradesh held that. So what was held in Ashwini Kumar Saxena? First option says board or committee functioning under Juvenile Justice Act is not expected to conduct a roving inquiry and to go behind certificates of birth to examine the correctness of the documents. Second says the board or committee must doubt the certificates and must always conduct a preliminary inquiry as to its correctness. And third says that cases where documents or certificates are found to be fabricated or manipulated, the court, the JJ board or the committee need to go for medical report for the age determination. So if you read this judgment, the first and third option are correct option. It is not required to go behind the certificates and see its correctness. Only if you are having doubt, then you find that these certificates are fabricated, manipulated, then medical report can be required, called up for the age determination. So option 1 and 3 is correct, which means A is the correct answer. Option A is the correct. So thank you so much for watching this video, and if you liked the video, please subscribe the channel and hit the bell icon to get notified of the next videos. Thank you so much for watching.